Minister in the Office of the Attorney General and Legal Affairs.
Madam President, I thank you most sincerely for recognizing me in this debate. Madam President, if I may steal a few seconds from the Senate's time, and in light of our tropical cycle number 2 warning, I just want to simply join in emphasizing, Madam President, to the citizens of Trinidad and Tobago, the importance of making the necessary arrangements to ensure their safety and security. Trinidad and Tobago, please, now is not the time for zessing, and certainly not the time for storm parties. Please be safe, Trinidad and Tobago. Madam President, to that end, I want to jump directly into the debate and, add my 2 pence to this very critical and important debate. To that end, I want to begin by congratulating Senator Vieira for always being a forward-thinking independent senator, a senator who's devoid of politics and certainly, in my estimation, a true patriot to Trinidad and Tobago, and someone who recognizes the importance of our growth as a nation away from, in this instance, the Privy Council and our colonial masters. So congratulations, Senator Vieira. So certainly I stand in support and join in the chorus with my other colleagues on the government bench as we add our support to this very, very critical motion. Madam President, the Honourable Patrick Manning, may God rest his beautiful soul, on April the 16th, 2005, on the historic occasion marking the inauguration of the Caribbean Court of Justice, said this, and I quote, "It was the late eminent Reginald Juris Sir Telford Georges who observed that to have independent countries referring legal jurisdiction to their former colonial masters is tantamount to a grown man who demonstrates his independence but continues to live in his parents' house. It is with great pleasure that I inform you that we have now found excellent accommodation and we are moving out." Close quote. Quotation. Today, Madam President, I want to put on the record my support for Senator Vieira's motion, my support to the Prime Minister, Dr. Keith Christopher Rowley, my support to the Honourable Attorney General to fulfill this country's treaty obligation to acceding to the CCJ as our final court of appeal, to replace, Madam President, the Judicial Committee of the Privy Council. The time is now, and I wish to say to Trinidad and Tobago and to the members of this Senate, we have found an excellent accommodation and we are moving out. Madam President, to that end, I want to focus on an article that I found in preparation for this particular debate. The Duke E. Pollard, in his book, Madam President, The Caribbean Court of Justice, and this is for the purpose of the Hansard, Closing the Circle of Independence, 204, in brackets, 2004, stated, "The establishment of the Caribbean Court of Justice in its appellate jurisdiction will signal the birth of autonomous judicial decision-making in member states of the Caribbean community and close the circles of independence which commenced as early as 1962. In a real sense, too, the establishment of the court will mark the culmination of initiatives to create our own regional institutions to facilitate and promote the development of an indigenous jurisprudence reflective of the moral, political, social, and economic imperatives of our region, and which commenced with the establishment of the Council of Legal Education in 1970. Madam President, to that end, I would like to highlight 2 critical points. Every time, Madam President, a case is before the CCJ and a judgment is delivered, we are aware that these judges are shaping and molding this region's jurisprudence. This is also one of the goals of the CCJ. Madam President, in a paper entitled The Caribbean Court of Justice and the Evolution of Caribbean Development, presented by Right Honourable Sir Dennis Byron, then President of the CCJ, at the 15th Annual Sir Arthur Lewis Institute of Social and Economic Studies Conference in April 2014 stated, one of the aims of the court as expressed in its strategic plan is to be innovative in the sense of fostering jurisprudence that is reflective of our history, values, and traditions, and consistent with the international law norms. Madam President, the CCJ in its appellate jurisdiction, as we are all aware, has addressed various issues ranging from civil, criminal, and constitutional law, areas ranging from death penalty to labor rights and other human rights areas. The Maestral Armand Claude, in the constitutional functions of the Caribbean Court of Justice, June 16, 2015, in a journal entitled McGill Journal of Dispute Resolution, Volume 1, Number 2, 2015, at page 70, Madam President, states, analysis of the many other decisions of the CCJ under its appellate jurisdiction reveals that the court is indeed marking a highly constructive contribution not only to the law of the three countries that have accepted its appellate jurisdiction, but also to the Caribbean region as a whole. The impact of its appellate jurisdiction will surely be felt even more as it's gradually adopted by other Caribbean states, end quote. In the same paper, Madam President, I referred to earlier, Sir Dennis Byron, he went on to further say that in the CCJ's appellate jurisdiction, the court has been able to clarify important doctrinal elements even in the Guyanese land law system, which is unique to Guyana, which is unique to our region. So, Madam President, this is one of the many reasons, at least based on the learning that I have presented and the literature that is available, why we stand in support of the development of regional jurisprudence. Adopting and supporting this motion is not a political gimmick. Adopting and supporting this motion is, as I began, the time has come for us as a nation to move out of our parents' home. Madam President, the CCJ esteemed judges are best positioned, in my respectful submission, to understand the realities that we face here in this region, and more specifically in Trinidad and Tobago. Recently, Madam President, hot off the press, as I may say, in an article that was in the newspaper on Saturday, June 25th, 2022, the Trinidad Guardian, to be clear, the article entitled Ramesh, the people must decide if to replace Privy Council with the CCJ, written by Raphael John Lal. And it stated, former finance minister and law lecturer Karen Nunes Teixeira, who also spoke at the seminar, gave the opinion that it is time the country starts to think about leaving the Privy Council, as it is a foreign institution that does not understand the cultural intricacies of Trinidad, and also the cost to go to the Privy Council is out of the reach of the majority of Trinidad and Tobago population. I am one, referring to Ms. Nunes Teixeira, I am one of those who believe that the time has come to take a leap of faith and to make the CCJ our final court of appeal. So, Madam President, just recent, and that is why I support Senator Vieira's motion, because here we have, even in 2020, conversations continuing relative to the importance of us breaking our ties from the Privy Council and, of course, turning to something that is ours, something that will be uniquely Caribbean, something that will be uniquely regional. Madam President, Chapter 4, page 46 of the Caribbean Court of Justice, an article entitled The Caribbean Court of Justice, The History and Analysis of the Debate, presented by Hugh Rawlings, lecturer in the Faculty of Law, UWI, published in the Caribbean Community 2000 Guyana. This paper states, Madam President, there has been an interesting assertion of justice, that justice cannot be divorced from local circumstances in which a case arises. And essential requirement of this assertion is that the adjudicators should be familiar with those circumstances and ideally should themselves spring from. The truth is, however, that the value which many persons in the Caribbean place on decisions of the Privy Council, as well as their respect and confidence in its administration of justice, is in part incidental to its location, far removed, Madam President, from the Caribbean. So, Madam President, this is an academic debate and has been ongoing for many, very, very many years. As Senator Vieira stated in his contribution, there is much literature on the CCJ, and me being the nerd that I am, thoroughly enjoyed preparing for this particular debate. Madam President, there are so many luminaries, some whose thoughts and contributions I've put on record today. And I took the time to do so to show, Madam President, that there is support throughout the region and locally that the CCJ is best positioned to foster and develop this jurisdiction's jurisprudence because of their understanding of our unique and varied legal matters. So, Madam President, as I get into the crux of my debate, it has been said that the Parliament, of course, it has been said that the Parliament is the highest court of the land. And if that is indeed true, Madam President, that makes you the honorable judge and members of this honorable Senate, ladies and gentlemen of the jury, together with members of the public. So if I am to approach this particular debate as if this was indeed the highest court of the land, my intention, as I would do in any court, of course, Madam President, would be to provide evidence to this court and evidence to the jury as it relates to this particular recital of Senator Vieira's motion. In Senator Vieira's motion, the Honorable Senator said, and whereas the unique and varied legal matters which arise in the Caribbean are far removed and foreign to the society, culture, and habits of the Judicial Committee of the Privy Council, as sentiment echoed by the Privy Council judges and senior British legal figures. That, Madam President, is the part of Senator Vieira's recital that I intend to focus on. And in an attempt to do so, I wish to present evidence to this honorable court as to why, focusing on 4 landmark decisions, Madam President, taking this honorable court through those 4 landmark decisions, emphasizing where it was critical for these matters to be tried before a court such as the CCJ, they understanding the peculiarities of our Caribbeanness and what makes us Caribbean. You know, Madam President, just yesterday, and I want to also use the opportunity to offer my sincere condolences to Justice of Appeal, Judge Malcolm Holdip, who laid to rest his 35-year-old daughter yesterday. Ariel, to be very was my very, very good friend. And the reason why I'm bringing up Ariel, and I want to read her name into the Hansard, Madam President, is because a very personal story. Ariel walked and was at my side throughout the length and breadth of the 2020 general election. She stays separate and apart from politics, but I'm her friend, so she supported me. And during that election, it was the first time I exposed myself to the public. And during the course of that election campaign, Madam President, on several occasions, of course, there would have been the trolls who attacked me based on the fact that I was too fat. There were those who attacked me on my eyebrow and my makeup. I talk about attacks. And I recall on one occasion during the election campaign, I went to her and I was in tears and I said to her, I can't take this anymore. Like, stop posting pictures of me because people will continue to talk about how fat I am. And this friend of mine said to me, she said, be your unique self. She said to me, be your authentic self. Do not allow anyone's perception of you to change who you are. And why I bring up that concept, why I bring up that idea of authenticity, Madam President, is because when we look at the Caribbean, we are indeed an authentic region. We are indeed an authentic nation. And I believe it is critical as it relates to our law because of how authentic we are. It is important for us to adopt the CCJ as our final appellate court because we will have judges sitting there who understand the peculiarities and the authenticity of us as a people and of us as a region. So, Madam President, as I indicated, my focus in this debate would be somewhat academic, in which I would focus on 4 decisions coming out of the CCJ, in which I respectfully submit to this honorable court, to this honorable Senate, to the people of Trinidad and Tobago, that had these matters been tried before the Privy Council, we may not have had the decisions we had coming out of these decisions. Reason being, the CCJ better understood our peculiarities, better understood our authenticity as a Caribbean people. Those decisions, Madam President, firstly is the case of Katrina Smith versus Albert Anthony, Peter Selby. It's a 2017 case, CCJ 13. Then there is the case of Ramdas versus Jairam and others, CCJ 2008 case, CCJ number 6. Then there is Maya Leaders Alliance versus the Attorney General of Belize, a 2015 decision, Madam President. McEwen 2018 CCJ case. These decisions, Madam President, which to my mind focus on certain unique aspects of us as a Caribbean nation, because these are cases spanning from Guyana to Barbados to Belize, different jurisdictions in which we required, which I respectfully submit, Madam President, having judges who understood the Caribbean identity and our, as Senator Vieira eloquently puts it in his recital, understood the unique and the culture, the society and habits of our Caribbean people. Now, Madam President, I may respectfully begin with the case of Katrina Smith versus Albert Anthony. Now, the facts of this case, Madam President, and in looking at these cases, for us to understand why I'm putting this on the record, I would be required to go through the facts, the issues and the law and analysis of these cases. Because, of course, by the time I get to the law and analysis, we will understand what the court took into consideration that was so uniquely Caribbean that allowed them to make a particular decision. Now, Madam President, in this particular case, this is a Bajan case. It came out of Barbados. The facts of that case, the deceased Albert Selby died intestate, and for the non-lawyers amongst us, he died without a will, which meant that his estate had to be administered in accordance with the Succession Act and the rules of intestacy. The deceased, Madam President, had no children, was predeceased by his parents and survived by his siblings, including the respondent, Mr. Albert Anthony Selby. The deceased was an unmarried man at the time of his death. However, he lived together with the appellant, Miss Smith, a man and woman, for more than 5 years, since April 2000 until he died. Now, Madam President, on the case reads, on the 6th of August 2020, the Court of Appeal Barbados declared Miss Smith as a spouse. However, the respondent, being the deceased's brother, appealed against the ruling. When the appeal was heard on the 14th of January 2016, the Court of Appeal reversed the decision that Katrina was the spouse of the deceased, whereby it rejected the decision of the trial judge that the word single in section 2 subsection 3 of the Act included a married man who was separated from his wife, and rejected also the alternate rationale that the term single was descriptive of a status of the parties had at the death of the deceased. Now, the issue coming, and this is just the bare bone facts, the issue in this matter that the court had to determine, Madam President, was whether Miss Smith who had been living with Mr. Selby as a man and wife immediately preceding his death was his spouse as defined in section 2 subsection 3 of the Succession Act, chapter 249 of Barbados, which prescribed that reference to a spouse includes a single woman who is living together with a single man as his wife for a period not less than 5 years immediately preceding the date of his death. So this matter, when it went to the appeal, as I said before, it was a matter really that required interpretation of the law. The controversy of this matter, Madam President, centers on the issue of whether the deceased was a single man immediately after preceding his death. The controversy in this case, Madam President, is derived from the view that there is a rigid distinction between literal and purposive approaches to the interpretation of the statutes. Now, let me turn to the law and the analysis. The CCJ, Madam President, in this matter had to examine the principles of statutory interpretation of the Bajan Succession Act, adopting and applying Lord Bingham dicta in the case of R versus Secretary of State for Health on the West Indian law reports, where it was held that the principles which the judges must apply when interpreting statutes included respect for the language of the Parliament, the context of the legislation, the primacy of the obligation to give effect to the intention of the Parliament. The CCJ decided, Madam President, that the primary function of a court was to give words the meaning Parliament intended, and was discerned by understanding the objective of the legislation, the change that it was aimed at producing, and its purpose. Now, Madam President, the CCJ looked at another case, Hayden's case, which is still relevant today, and highlighted that it is the duty, Madam President, of a court to consider the mischief and intended remedies which made it necessary to pass legislation and to add force to the intended cure according to the intent of Parliament for the benefit of its people. Now, the CCJ also considered comments from academics in its interpretation exercise about the social and this was actually found in the obiter comments of the case. So the CCJ also considered comments from academics about the social and historical context within which the act was enacted, and found, Madam President, that the act was just a social legislation to address one of the realities of a Caribbean society that had not been reflected in the common law or statute inherited or adopted from England, whereby persons living together as man and wife but were not married to each other, and their children had not been recognized in the colonial legal and judicial regime, with unfair results. Therefore, the right to inherit was dependent on the status of marriage. In this case, Madam President, the CCJ noted that on the death of a partner in a non-marital union, in the absence of a will, the survivor had no right to inherit or otherwise benefit from the deceased's estate, regardless of the quality or duration of that union. Conversely, a person who was married to a deceased could inherit regardless of the quality or the duration of the marriage, whether it's an empty shell marriage or not. Based on the law, you were entitled, pursuant to that archaic colonial law, you were entitled, Madam President, to benefit, whether the survivor and the deceased had been living at the time of death in another non-marital union. And as we say, local parlance, whether it was honing or not, had an outside relationship or not, based on that archaic law, you could have benefited. So the CCJ in this case, in looking at the social circumstances, said we will not have it, in essence. We will not have it because the reality, as we know in the Caribbean, there are many common law relationships in which man and woman live better than married husband and wife. And the CCJ, in understanding our unique realities, understood that it was important to give recognition to women and persons in Barbados who lived in this kind of relationship. Now, in conclusion, Madam President, the CCJ reviewed Section 2.3 of the Succession Act 249 as a whole and found that Section 2.3 changed the definition of spouse for the purpose of inheritance under the Act to include a single person who was not married to and who cohabitated with the deceased for 5 years immediately preceding the death, provided the deceased was not married to someone else. The court, Madam President, decided that the mischief the act intended to remedy and the solution it prescribed, meaning the CCJ, were clear. The right of the survivor of a non-marital union to benefit from the estate of the deceased partner was not dependent on the status of the marriage, but on the duration of the cohabitation with the deceased immediately preceding death. In this case, the statutory period of cohabitation for 5 years immediately before the death of the deceased was determinative of the right to inherit as a spouse, as this could have been used as a credible indicator of a commitment to a true union comparable to a formal marriage. So, Madam President, I particularly, having practiced in the family court and having had to deal with so many women who would have come to me who had cohabitational relationships and who were told by their spouse, their cohabitational spouse at the time, that you wasn't getting a thing because you was never married to me. One can imagine how pleased I was when I was in practice to know that this was the kind of learning that was coming out of the CCJ, a court that truly understands the peculiar, and I started by saying the authenticity of us as a Caribbean people. So this is one of the cases that I've presented to this honorable court with the hope that at least when it comes to voting on this motion, we would be able to do so, understanding that this case, that the CCJ has played a critical role in developing our jurisprudence, yes, but more so, it is best positioned to make said decisions, because what we would have is our own people, Caribbean brothers and sisters, Caribbean luminaries sitting there called upon to make a decision. And mind you, this is not an emotional, because I know the opposition in the previous debate spoke about this as in speaking about Senator Vieira's opening statement, spoke about, this is not an emotional debate. But we have to, unfortunately, in this debate, we have to put some emotions in it. And we have to understand that the CCJ would be best positioned, as I said before, based on understanding our unique Caribbeanness to make certain decisions. Now, as I would have indicated in my introduction, Madam President, throughout the course of this contribution, I would look at cases. The other case that I want to turn to, Madam President, is the case of Ramdas and Jairam and others, CCJ 2008. This is a Guyanese case. And again, the part of Senator Vieira's recital that I would be focusing on is, and whereas the unique and varied legal matters which arise in the Caribbean are far removed and foreign to the society, culture, and habits of the Judicial Committee of the Privy Council, as sentiment echoed by the Privy Council judges and senior British legal figures. Now, in this case, again, if I may respectfully take this Honourable Senate through the length and breadth of this case, Madam President, generally, the facts of this case. The appellant, Ramdas, and the first respondent, Loki, were brother and sisters. Loki inherited land from her husband and had agreed to sell to her brother 36 acres for the sum of $30,000. Subsequent to this, Madam President, Loki also entered, for the smart manism that is also uniquely ours as a Caribbean people sometimes. Loki also entered into an agreement of a sale with Ali Muhammad under which she sold for the sum of $125,000 all of the land which she had inherited from her husband, including the 36 acres which she had earlier sold to poor Ramdas. This resulted in litigation, Madam President, when Ramdas was granted an injunction by the court restraining Mohammed from entering his portion of land. In his pleadings, Madam President, Ramdas alleged that Loki and Mohammed fraudulently passed transport, because that's what transfers are referred to in the Guyanese jurisdiction. It's not referred to as a deed, it's referred to as transport, to Mohammed in order to defraud him of property. Ramdas filed action against Loki, Mohammed, and the Registrar of Deeds, seeking specific performance of his agreement with Loki and revocation of Mohammed's transport. In essence, the revocation of Mohammed's deed based on fraud. Now, the issue in this particular case, Madam President, raised was whether equitable interests in land in Guyana are recognized or can be acquired having regard to the development of the law of immovable property in Guyana, particularly in relation to a purchaser who is put in possession under an agreement of sale. And immovable properties are like chattel houses that we are aware of, that is so unique to the Caribbean as well, right? Now, let's turn to the law and analysis in this particular case. Guyana, Madam President, has a hybrid land law system, and for those who would have practiced in other jurisdictions, I would understand, or even just through law school, because I have not practiced in Guyana, but just in going through law school and having Guyanese friends, you understand that their land law system is a mixture, Madam President, of the Roman Dutch law and English common law, which is unique and by far more complex than I believe any land law system that exists in the entire world. Now, so complex in its own right. In its appellate jurisdiction, Madam President, the CCJ has been able to clarify important doctrinal elements of the Guyanese land law, offering clarity, legal certainty, and stability to the Guyanese community on many of these land issues, and Ramdas and Jairam being one of those cases. Now, the court in this case, Madam President, would have had to examine Section 3 of the Civil Law of Guyana Act, Chapter 601, subsection B, which states, the common law of Guyana shall be the common law of England at the time the date aforesaid, including therewith. Well, you know how these things are drafted. The doctrines of equity as then administered or at any time hereafter administered by the Court of Justice in England, and the High Court shall administer the doctrines of equity in the same manner as the High Court of Justice in England administers them at the time aforesaid or at any time hereafter. So that is an excerpt actually taken from Section 3, subsection B of the Guyanese Civil Law, the Civil Law of Guyana Act. Now, subsection C of that same section, so we have section 3, subsection B of that same law states, the English common law of real property shall not apply to immovable property in Guyana. And then it goes on to say in subsection D, there shall be as heretofore one common law for both immovable and movable property, and all questions removing to immovable property in Guyana and to movable property subject to the law of Guyana shall be adjusted, determined, construed, and enforced as far as possible according to the principles of common law in England applicable to personal property. So here we had wholesale in the Guyanese, in this particular act, Section 3 of the Civil Law of Guyana Act, adopting and mandating legislatively that once cases in Guyana, so it means irrespective of how unique your case was, if you relied upon the law to the letter or the law that was on the books, decisions could only be made based on what happened, how the British would have applied the law in their circumstances. So this, in essence, was the junjat that the court was faced, the CCJ was faced when this case came before it. Therefore, through this provision provision, it is provided expressly, Madam President, based on what I just said, that the English common law of real property was not to apply to immovable property in Guyana, and that there was to be one common law for both immovable and movable property, meaning chattel houses, with the proviso that immovable property may be held in full ownership, which shall be the only ownership of immovable property recognized by the common law. Now, the concept, Madam President, as I indicated before, of chattel houses known to the English law, notably in the case of Ellingstone Limited versus Morris, which questioned whether a bungalow situated on top of concrete blocks but was not attached to them form part and parcel of the land itself. This is a peculiar phenomenon in the Caribbean society, and most Caribbean territories have given it statutory recognition. It was held, Madam President, in Ellingstone that it cannot be removed without being destroyed, then it is more than like, if it cannot be removed, without being destroyed, then it's more than likely a fixture. Now, therefore, though the judges, Madam President, of the Privy Council, in this particular case, though they understand the concept of chattel houses, which is still existing at the very, and is very common to us in the Caribbean, there are key societal issues unique to us, Madam President, to consider arising out of the issues of chattel houses.
Minister, you have 5 more minutes.
Thank you, Madam President. Arising out of the issues of chattel houses, movable properties which they may not appreciate and relate to, such as fraud, such as land grabbing, such as bribery and collusion. It must further be noted that certain aspects of the English law will not reflect on our needs, cultural traditions, and regional objectives. Through the CCJ, Madam President, we can be proud as a region that the people of the Caribbean region will now be placed in a position to take control of the administration of its own justice, as has been the case in relation to other aspects of our regional responsibilities. Madam President, a prime example of land fraud occurring in Trinidad and Tobago is the Caroni 1975 land issues surrounding fraudsters and people offering deals for sale, which we are dealing with as a national and regional issue, especially in relation to unregistered deeds, which are deemed to be fraudulent and void. With this in mind, Madam President, I ask the simple question: can a judge in the Privy Council fully understand and have an appreciation for culture and determine whether a chattel house on blocks in a community in Georgetown, Guyana, belongs to the occupant or the owner of the land? And my answer to that, Madam President, is no. Madam President, or can judges of the Privy Council appreciate and knowledgeably determine matters related, let's say, to Susu that exists in Trinidad, which have been common, especially in rural communities in Trinidad and Tobago? My answer to that is no. In actually preparation for this particular matter, I saw that there was a matter some time ago, I think it's in Princess Town, where a lady brought a matter for obia against her neighbor for practicing obia. And that was actually the case. It's a matter based on obia. I remember when I was practicing law, there was actually a counsel, and of course I would not mention his name, who said he had to run, it was a murder trial, and was attempting to run a defense based on obia, that the man got shaft from a obia man. And therefore when he was acting in a, I'm sorry to laugh, but he was acting in a particular way because he was under the influence of obia. You can imagine case. Now, of course, in the UK, they have dealt with witchcraft, but that act that dealt with witchcraft, I understand, has been repealed, and so therefore there's no law at all in the UK that deals with the issue of witchcraft. But in our Summary Courts Act, even in Trinidad and Tobago, there is recognition to issues of, well, for want of a better word, obia matters. So, Madam President, all that being said, I know time is against me, and unfortunately, I do not have the time to go through the other cases that I intended to put on the record.
Senator Nakid, just 1 second. Senator Nakid, please apologize for that statement. Please rise and, yes. Thank you. Continue, Minister.
Thank you, Madam President. So I don't know if certain people in here under Obia too, they're acting enough. Anyway, I'll move away from that. Madam President, the point that I want to make, most respectfully, is that, of course, I stand in support of Senator Vieira's motion, recognizing that we are peculiar and we are authentic as a people. And as the then Prime Minister Manning said, the time has come. We have found an excellent accommodation, and like it or not, we are moving out. I thank you, Madam President.
Senator Roberts.